It's an old and contentious issue now. Questions about the use of race in college admissions. They have been asked, answered, debated, discussed, argued over for decades, and now they're heading to the nation's highest court. This week, the Supreme Court justices announced they will take up a pair of cases to reconsider the legality of affirmative action under the Constitution and our civil rights laws, as they invoke some of the oldest and most elite schools, as well as state schools. A decision could be sweeping right across the higher education landscape, maybe into private hiring at companies and federal contracting, all kinds of other areas. So our ABC News senior reporter on this, Devin Dwyer, joins us with the details. Devin, you're up at the court so often. You're following these cases. The morning they came down, you were right on it. So who brought these challenges and what's at stake?
Yeah, Terry, these are cases brought by a group of conservative students, mostly Asian Americans, who say they were discriminated against by Harvard University and the University of North Carolina in favor of black and Hispanic students, essentially discriminated against on the basis of race. And they've been organized by a longtime opponent of affirmative action. His name is Edward Bloom. And so this case is really a test for this court, the 6-3 conservative court, on where race factors in so many of our policies, but of course in education and in admissions. And if it feels like we've been here before and this question has been settled, it's because it has. The Supreme Court has weighed in several times over the years, as you know well, and decided this issue. It's been long considered, settled, established law that schools can use race as a factor in deciding the admission of students. But now with this new conservative majority and this engineered case, the conservative justices will get a chance to take a second look at it, and many are expecting it may not fare very well, the policy.
It may not fare very well, in part because while the Supreme Court has upheld race-conscious admissions, hasn't done so really enthusiastically, going all the way back to the Bakke case back in the 1970s. And one of the landmark reaffirmations of the constitutionality, the legality of affirmative action, was the Grutter versus Bollinger case in 2003. Sandra Day O'Connor, the crucial vote there, saying, yes, affirmative action can move forward. But she said, I've got here, the court expects that 25 years from now, she wrote for the court in 2003, the use of racial preferences will no longer be necessary to further diversity in education. So Senator Day O'Connor said, yeah, but let's put a time limit on this. While it hasn't been 25 years, it's close at this point. I wonder if the way the court has almost reluctantly upheld affirmative action will make it easier for those conservatives, those new conservatives in control of the court, to just steamroll it and outlaw it.
Yeah, it sure seems like it, Terry. I mean, every single one of those decisions that you mentioned and others were decided by just one vote, which gives you a sense of just how contentious and narrowly divided both the court and the country are on this issue. And so much has changed just in the 6 years since the last time they looked at affirmative action. That was 2016. Now, of course, we've lost Justice Anthony Kennedy, who wrote that opinion. He said there's an intangible value in building a diverse student body, and students should have, schools rather, should have some leeway in building that. He's gone. Ruth Bader Ginsburg, a staunch advocate, is gone. And of course, there are now 3 very conservative justices appointed by President Trump. And of course, the man in the middle, Chief Justice John Roberts, somebody who we've talked about as sort of not having the power he once had, actually on this case might be a leader. I mean, he is, Terry, as you know, someone very opposed to the use of race in any policy. He, in fact, famously wrote in a dissent in 2016, the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And so, even though he's kind of emerged recently as sort of a moderate voice in the court, I think we can pretty safely assume where he'll fall on this one. And so the stakes, as you mentioned at the top, quite significant. And even as these cases are preparing for argument likely in the fall, those groups supporting affirmative action says it still has value. They're really preparing for battle on this one, Terry.
Well, and as you point out, look, it looks like Chief Justice Roberts and the others are on the record that affirmative action should be outlawed. But it's not the same kind of affirmative action that it was 40 years ago when it was
That's right.
when it was first fought over in the courts, when it was hard mechanical quotas. Now, as Justice Kennedy suggested in his opinion, upholding it a few years back, it's really a kind of more holistic approach. The value of diversity in a learning community, the value of different voices, the way it improves education and scholastic work, to have a lot of people from a lot of different backgrounds. And in America, given our history, having black Americans enrich the discussion in colleges and universities. It's a very different kind of affirmative action, but the Supreme Court really isn't going to take that into account at all, it sounds.
No, and you know, the schools are making the very point you're making, Terry. I mean, they say that the characterizations are way off of what's actually going on in their admissions chambers at the elite universities in this country. They point out, as you do, this is not about quotas, but they say one factor among many. In fact, Harvard talks about it as a tiebreaker, a highly selective group of very successful and talented candidates for their undergraduate classes. They say race is just one sort of chip that they may look at when trying to cast that, that learning environment. And, you know, a number of studies since these cases were decided have shown real value in building a diverse student body, one that accounts for race in terms of educating our future leaders, and, of course, advancing minorities. I mean, this policy emerged in the wake of the civil rights movement in the 60s as a way to support historically disadvantaged communities, and those communities insist there's still very much a big need for that policy today, Terry.
There is that cartoon version of affirmative action still in the public mind. A very different case is being presented to the Supreme Court, which is basically going to strike it down regardless, it sounds like. Devin Dwyer will be with you on this case, on these cases as they move forward through the year. We will.
Thanks
very much.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.